You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
Today, I'm announcing actions to bar migrants who cross our southern border unlawfully from receiving asylum.
On Tuesday, President Joe Biden announced a sweeping executive action making it harder for migrants who illegally cross the southern border to get asylum. His most significant action to address the migrant crisis that has threatened his reelection. Biden said the Republicans left him no choice but to act alone when they blocked a bipartisan border agreement.
I'm moving past Republican obstruction and using the executive authorities available to me as president to do what I can on my own to address the border.
Biden's executive action was criticized by both Republicans and progressives in his own party, and former President Donald Trump slammed the move during a rally.
It's really pro-illegal immigration. It's great for illegal immigration.
Immigrants' rights advocates say they'll sue the Biden administration over these asylum restrictions, just as they successfully sued the Trump administration. Joining me is Leon Fresco, a partner at Holland Knight. He was the head of the Office of Immigration Litigation at the Justice Department during the Obama administration. Leon, tell us about this new policy.
Starting now, if anyone tries to cross the border illegally in between the ports of entry and ask for asylum, they will be banned from doing it unless they were a victim of human trafficking or had some sort of urgent medical or humanitarian issue that was immediately evident to the Border Patrol officials who apprehended the person. There is a trigger that's being put in by executive order that's using the travel ban authority, which President Trump used many times during his presidency. And what they're saying is that if there's ever a situation where more than 2,500 people per day, on average, are crossing over any given week, that gives them the authority to trigger this ban procedure until such time as the daily crossings go down to 1,500 people a week, which the last time that's happened was during COVID, where nobody was traveling anywhere. And at the moment, because we have something around 3,500 to 4,000 crossings per day, that exceeds the 2,500 person threshold, which is why the border will shut down. And essentially, people asking for asylum who are crossing the border will not be allowed to do that any longer.
Are they allowed to apply for asylum at the ports of entry?
With regard to the ports of entry, there are appointments on an app on your phone called CBP One, and there are about 1,500 of those appointments every day, and those will still be available, and people will still be allowed to do that because that's an orderly process and one people can use without creating chaos on the border, as opposed to they will not be able to cross in between the ports of entry and ask for asylum. They will be, according to this executive order, returned back, which was the same thing that was being done with COVID under the Title 42 COVID authority.
He's tapping executive powers outlined in Section 212F of the Immigration and Nationality Act. And that's the same law that former President Trump used in the Muslim ban of 2017 and the 2018 suspension of entry of migrants between the ports of entry. Explain what that law does.
So here's where this is going to get a little complicated, June, and I want you and your listeners to try to stay with me here because it will all make sense in a second. The statute, all it says is that the president, if the president thinks it's not in the national interest of the United States, may ban the entry of any category of non-citizens that the president deems is not in the national interest of the United States to let them enter. So that is simple when the foreign national is outside the United States. So suppose you're at a U.S. embassy in India and you're applying for a visa. If there's a ban on Indian immigration that the president put in on INA Section 212F, very simple, no visa can be issued. Or if you're at an airport in Canada, you're trying to fly to the United States, and there's a ban on flying from Canada to the United States because we banned Canadians from coming in. That's a very easy ban to enact too. Where it gets complicated is when someone has already crossed the border and has already entered the United States, then this is a very important word, entry. This becomes a complicated issue because when you enter the United States illegally, that's what makes you subject to prosecution for illegal entry. You have to have an entry. It's an element of the crime. Here's where this is problematic. Biden is saying that this power to restrict entry also applies to people who've already entered. And that's what's going to be the debate in the courts, is whether that's true or not, because there's a very strong argument that if Congress had meant that, it would have said that. This is now going to be about, can you pretend that someone who just entered minutes ago didn't really enter, such that you can kick them out like if they were applying in India for a visa? But if that's true, then does that eliminate, by the same token, the federal government's ability to ever prosecute anyone again for illegal entry? Because that's why we prosecute people, because we caught them 10 minutes after entering. I don't know how courts can thread that needle and try to have both sides of both of these arguments.
There always seems to be a catch with immigration law. Maybe the courts will look up dictionary definitions of entry to see if they can engage in this legal fiction. Now, immigration advocates and progressives complain that this is just what Trump did. But the administration has said this is not comparable to Trump's system-wide crackdowns. What do you think? It sounds a lot like it.
It is almost identical to what Trump did, with the exception that they made some carve-outs for unaccompanied children, which is required under the Trafficking Victims Protection Act. And also, they made exceptions for people with urgent medical and humanitarian claims and victims of human trafficking. But at the end of the day, all of those screenings are going to be done very quickly by someone who's a Border Patrol officer. That might not be their top priority at the moment. They may have a security agenda that they're trying to fulfill. And so asking if someone's been human trafficked may not be at the moment top of mind. And so what ends up happening is, in its implementation, it ends up being almost identical to the Trump ban.
The attorney at the ACLU, who successfully sued the Trump administration, Lee Gallant, said, "A ban on asylum is illegal, just as it was when Trump unsuccessfully tried it." Was the argument in that case the same as the argument you've been describing for us?
That was the exact argument, which is that the asylum statute specifically says it doesn't matter how you enter, legally, illegally, anything else. It doesn't matter. You can still apply for asylum. Now, this executive order means you can't apply for anything. We're trying to do exactly what COVID did. That lets you kick people out. And the question is, will this entry be considered a fiction or not? And if it's considered a fiction, then maybe the Supreme Court lets Biden get away with this. We know the Ninth Circuit has binding precedent on this. So the Ninth Circuit would actually have to go en banc and reverse itself, which is very unlikely, if they're going to overrule this precedent on the issue of entry and asylum. So the only hope that the Biden administration is going to have is to go to the Supreme Court.
For Biden to win, is it going to be the Supreme Court justices, or at least 5 of them, saying wink, wink, nod, nod, it's okay?
Correct. Will the Supreme Court ultimately give leeway to the Biden administration to say that, yes, for this purpose, an entry doesn't count as an entry if we caught you 10 minutes after you entered? We will pretend that you still didn't enter. He's going to need that. And then there's a second wrinkle we haven't even talked about yet. He's then going to need the cooperation of the Mexican government to repatriate people who are not Mexicans into Mexico, which the Mexican government has no obligation to do. They're doing it right now as a favor to Americans at a rate of $30,000 per month, but this would require much more than that. Remember, we're talking about at the moment 4,000 people per day. So if we do some amateur mathematics here, we're talking about 120,000 people per month. Is the Mexican government, especially after this election, likely to do that?
Leon, you seem pretty sure that once the lawsuits are filed, this executive order is going to be enjoined.
Yeah, this thing is going to be enjoined, just because it's binding Ninth Circuit precedent. But I do think the Biden administration understands, because they have very smart lawyers that are there, that the way this is going to play out is they've written the executive order. Now it's going to be implemented. It will be immediately sued. There will be an immediate injunction. So the order goes away, and then they try to appeal to the Ninth Circuit and the Supreme Court. Will be very interesting to see if they try to take a fast track or if they try to take a slow track. That will be very indicative of whether this was meant to be a political gambit or whether this was meant to be a legitimate border operation and procedure. If they take the slow road, then we know this is over because nothing's going to happen until the election. If they take the fast road, I suppose the Supreme Court can, within the next 30 days or so, decide whether they want to stay an injunction and allow this to go into effect. And we'll have to wait and see.
Administration officials said that individuals will be removed to their country of origin in a matter of days, if not hours. Does the Biden administration have enough resources to expel migrants that quickly?
So the answer to that question is going to be it depends what country the person is from. For instance, if they're from Venezuela, Venezuela is not accepting people we're trying to deport. And Cuba is not really accepting people we're trying to deport. And Haiti has some very difficult conditions right now, so it's difficult to deport people in large scale. And so you start adding all of those up, and you start getting significant chunks of people that you cannot deport very quickly. China's another one. What are you going to be doing with all of those people who are crossing the border? Nothing really is going to be changing there unless Mexico lets you bring them back into Mexico, but then they become Mexico's problem. And then the question is, well, how long is Mexico willing to deal with such a surge of people inside of Mexico? So that's the complication here. But at the end of the day, that's where we're at.
Much more legally complex than it seems at first. Thanks so much for taking us through it, Leon. That's Leon Fresco of Holland Knight. Coming up next, the first son of a U.S. president to be prosecuted. I'm June Grasso, and you're listening to Bloomberg. The first trial of a sitting president's son has been nothing if not dramatic. Hunter Biden is charged with buying a gun while addicted to drugs, and the prosecution has attempted to show, in a rather sensationalized way, that Biden was driven by his crack addiction, with testimony from his ex-wife and former lovers who describe seeing him in the throes of addiction, with pictures of Biden with crack pipes, passed out or disheveled, and with his own voice describing his descent into drugs in an audiobook of his memoir.
I had no plan beyond the moment-to-moment demands of the crack pipe.
The 3 felonies are all connected to Biden's checking no on a single box on a federal gun application that asked whether he was, quote, an unlawful user of or addicted to drugs. Joining me is former federal prosecutor Joshua Naftalis of Pallas Partners. Hunter Biden has been charged with 3 felonies: lying to a federally licensed gun dealer, making a false claim on the application by saying he was not a drug user, and illegally having the gun for 11 days. Is it unusual to charge 3 felonies all based on the same action?
It's not necessarily unusual. The way prosecutors think of it is give them 3 bites at the apple with the jury. So if the jury only has 1 count to consider, prosecutors could think, well, I only have 1 shot at a conviction, whereas this gives them an opportunity to get some sort of a compromise verdict where, they'll still win if they get 1 conviction. But since the facts themselves are relatively simple, I don't think you necessarily need to charge them 3 times for the same conduct.
You have a drug addict with no criminal history misrepresenting his addiction, allegedly misrepresenting his addiction on the purchase of a firearm which he did not use. How often is that prosecuted? I mean, have you heard of any other prosecutions for this?
This is a very specific crime to charge, and my understanding is it's very rarely charged. The idea that someone lied allegedly on a form about a firearm that he owned for 11 days. Usually these sort of cases are brought because, as you said, the firearm was used in some way, was fired, and they're looking to hold the person to account. Here, there was no harm, and obviously it's in dispute as to whether he even lied. So I think there is a good argument that this is the type of case that's not typically brought, and but for the fact that it's the president's son, it would not have been brought.
Much of the prosecution's case has centered on showing the seriousness of Hunter Biden's addiction. Smoking crack from the minute he got up and every 20 minutes, according to an ex-girlfriend. But it's also painting him just as a bad guy. I mean, cheating on his wife, getting his late brother's widow addicted to crack, drug-fueled lifestyle. And then, the pictures they have of him in a bathtub holding a crack pipe, et cetera, et cetera. Is the prosecution actually trying to paint him as a bad guy?
So I think that's a great point. I mean, I think what they're trying to do, they don't have a witness who could say, as of the date that Mr. Biden signed the forms, he was addicted. They don't have that. What they have is ex-girlfriends who said he was a drug user before and potentially after. They obviously have his biography, and they're trying to dirty him up to make it look like this really was an addict. It could backfire, right? If you try to smear somebody, it can turn off jurors. And I think that's one of the things that the prosecution may be overplaying its hand, because they're certainly trying to smear him in a way to make him just look like, as you said, an addict who was drug-fueled, he was cheating on his wife, that this is just a bad guy. But there are plenty of people who may be sympathetic to someone like him.
Not only plenty of people, but perhaps some of the jurors, because 4 of the jurors say either a close family member or a close friend was addicted to drugs. So they may see his addiction in another way, as gut-wrenching and hard to overcome, and maybe that he didn't know what he was doing when he filled out the form.
Yeah, exactly. I mean, I think the defense is trying to prove that it wasn't a lie at the time it was told. And they're also going to try to paint him as an imperfect man, but this isn't the type of person that needs to be sent to jail. And that's the kind of narrative they can register with. You only need one to hang the jury, to register with them and say, I have people in my family who have battled drug addiction. But that doesn't mean that that's the type of person who should be sent to jail for buying a firearm when no harm was done. So, yes, and I think that it's hard given who he is. As much as they've tried to screen out, I'm sure, people who have political views, it's the president's son. And I think it's very hard for people to really put that out of their mind. Like, why are we going after and smearing this man for a crime that isn't typically enforced?
Speaking about being the president's son, the First Lady, Jill Biden, has been in the courtroom for most days of the trial, sitting behind her son. And you usually see family members sitting behind the defendants, offering their moral support. But would it be problematic in this case if there is a juror who's not a Biden fan?
The juror is going to be instructed that who Hunter Biden is shouldn't play any role in their deliberations. So I think everyone's hope is the fact that you may not like President Biden shouldn't affect how you vote on Hunter Biden. But having your mom show up is something that I think is often important to jurors. This is a person with a family. He's being smeared for being, an adulterer, for being a drug addict, and his mom shows up to support him, and she is the First Lady, after all. And that really, I think, reinforces subconsciously that this is a case that some people may disagree with.
The prosecution has played a lot of clips of Biden's memoir. Do you think that's strong evidence?
I actually think this is their best evidence in terms of they can say that Hunter Biden admitted in his memoir that he was addicted to crack. I haven't read the book. I don't know if he says between these dates and these dates, including when I bought the gun, I was addicted to crack. But it's pretty good evidence when someone writes a book and then the audiobook is narrated by him. So it's his own voice saying, I was an addict. But I think this is sort of like the simplest and most elegant way for them to say, like, what are we talking about? The guy admitted to it.
Let's talk about the defense. The defense attorney, Abby Lowell, said in his opening statement that Hunter Biden didn't knowingly lie, didn't knowingly violate the law, and the prosecution won't be able to prove beyond a reasonable doubt what Hunter Biden's state of mind was when he filled out the form. Is that a good defense?
I mean, I think it is a good argument. It's sort of it's like a lawyer's argument in a way, which can register with the jury, which is it's impossible to get inside someone's head as to what they were thinking. And this isn't the type of case where they really have a witness who can say, Mr. Biden confessed to me that he knowingly filled out the form wrong. And then they call that witness to say, oh, he knew what he was doing was wrong. This is someone's interpretation, as argued, as to what it means to be an addict. And he didn't consider himself an addict, to be addicted. Yes, he may have used drugs before and after. He filled out the form, months before and maybe months after. But at the time, he didn't think he was lying. And in the end, that's all that matters is what did he think he was doing was wrong. So, it's the kind of argument that could work. It's also his best argument, which is to say he didn't lie, so you can't convict him.
The other, even more technical argument is the defense says the law prohibits someone who is using drugs from buying a gun, and the form asks an applicant if they are a user of drugs. So Biden may not have been using drugs at the time, whereas the prosecution says the law doesn't require the prosecution to prove he was using drugs on the day he bought the gun. Is that a jury question, or should that be a question for the judge?
It depends how the judge instructs them on the law, but I think it's the kind of argument they can register with the jury, which is there an ambiguity in this form such that you shouldn't convict on it? If it says, are you a drug user, that could mean, are you using it now as I signed the form, and it's supposed to sort of tip you off that you probably shouldn't be buying a gun when you're high? Or does it mean, are you sort of in this time period using drugs? So, in terms of the argument, it's certainly not a bad argument. It's the kind of argument that when you fill out the form as a juror, you may say, like, well, I could misunderstand that question. I can't convict somebody.
The prosecution has brought on his ex-wife, his ex-girlfriend, and none of them can testify to his being addicted to crack at the time he bought the gun. The closest they have come is that Hallie Biden, his brother's widow, whom he had an affair with, testified that on October 23rd, she found the gun, remnants of crack cocaine, and some paraphernalia. But she wasn't able to say whether Biden was on drugs the day he bought the gun. That was October 12th. That's as close as they get. Do you think they have to get closer than that?
I mean, I think the prosecution's going to argue, you don't have the paraphernalia if you're not a user. But what the defense will probably say in their closing is, they brought in these women who, many of whom didn't want to be there. They were subpoenaed and did everything they could to prove he was a user, and they don't have anybody, including people who loved him and were in a relationship with him. So who would know him better? So it may be enough to win. So I think this comes back to the backfiring argument, which is, my sense is that these are not really willing witnesses. They're answering the questions because they've been compelled to do so. And if the people who are compelled to do so are sympathetic, that can help Mr. Biden.
What about the charge of illegally having the gun for 11 days? Will these same defenses work to counter that as well?
So what's interesting is, he's not being charged with using the gun in connection with, for example, a narcotics transaction. That's sort of often how firearm offenses are charged in the federal system, which is you're a drug dealer, you sell drugs, and you have a gun, and therefore you can charge the use of the gun. Possessing a gun is not a federal crime on its own. It's a false statements case. So I think, to come back to the earlier question, it's really not a case about his using the gun, owning it for 11 days. It's, did he fill out the form wrong and lie? And I think that just shows sort of the potential overreach that the defense is going to say, this really isn't a federal case. They're trying to make it a federal case.
The defense started presenting its case on Friday, and Hunter Biden's daughter, Naomi, testified about visiting her father while he was at a California rehab center, and that he seemed to be improving in the weeks before he bought the revolver.
Yeah, and I think that to the extent that this is a soap opera, that will complete the story for the jury, which is, the government has picked people who were close to him and they can't pin it on him, but they're also trying to depict him in the worst light. And here Mr. Biden apparently is going to call people who will say, actually, he was not addicted at the time. And in fact, the government's presenting a very cropped view as to who this man is. So strategically, I think that makes sense, which is they're going to humanize him and also try to put a lie to the government's depiction of Mr. Biden, that that's just not who he is. Yes, maybe he had a drug problem in the past, but that doesn't mean he's done anything wrong here.
Soap opera is a great way to describe this. There's as much happening outside the trial as inside the trial. I mean, Hunter Biden walked into court on Thursday with a copy of his memoir under his arm. He has friends and family there all the time, and there was sort of a prayer circle one morning. And apparently, during jury selection, at every break, he would go over to his mother and wife and kiss them. I don't know if it's sincere, it's for the press, it's for the jury.
I mean, a lot of in-court, as you know, in-court dynamics are choreographed, which is make sure you greet your family, make sure you smile at the jury. Maybe you'll bring your book, because, the jury is judging you when you're sitting there, not just when you testify or other witnesses are testifying. They're looking at you, and you want to speak to them with your sort of presentation that you're a good guy, basically.
Biden's defense team said they want to take the weekend to decide whether the defendant will take the stand in his own defense. What do you think?
My guess is that he does not testify, because the argument the defense is making is that this is sort of a crime that should never have been charged, and you haven't met your burden. And to have him get up there and testify is going to put more focus on him, and then they're going to be able to, again, march through, when was the last time you used drugs? My guess is that it could end up backfiring again. Obviously, there's a temptation to want to testify and say, this is ridiculous, but I think that he has enough problems, including his past affairs and drug use, that they would sort of try to smear him again. It's not the type of case you'd necessarily want your client to testify in.
We'll find out on Monday for sure. Thanks, Josh. That's Joshua Naftalis of Pallas Partners. Coming up next, the Steakhouse Stakeout. I'm June Grasso, and you're listening to Bloomberg. Since his indictment on bribery charges, New Jersey Senator Bob Menendez has seen his political support vaporize in both the Senate and New Jersey, where he's derided as Gold Bar Bob. The Democrat maintains he's innocent of the charges of accepting nearly $500,000 in cash, 13 gold bars, and a Mercedes-Benz in bribes in exchange for favors.
I am disappointed at the false accusations as well. All I can ask of you is to withhold judgment until justice takes place.
Through 4 weeks of trial, the jury has been hearing lengthy testimony about a complex bribery scheme as prosecutors introduced evidence of emails, phone recordings, bank records, gold bars, and hundreds of thousands of dollars in cash. But the testimony picked up this week, and jurors were riveted when an undercover FBI agent took the stand and showed them a secret video recording of Menendez dining and laughing with the wine flowing at an upscale D.C. steakhouse with his girlfriend, now wife Nadine, his co-defendant Will Hanna, and 2 Egyptian men. In what can only be described as a stroke of bad luck, the FBI surveillance teams were there to watch someone else and just happened to recognize Menendez and hear an incriminating statement. Joining me is Bloomberg legal reporter David Voreacos, who was in the courtroom for the testimony. So, David, we don't even know if Menendez was on the FBI's radar at the time of this dinner.
In 2019, the FBI surveilled a group of people at Morton's Steakhouse in Washington, and the target of that investigation, we learned in testimony in court this week, was not Bob Menendez, but someone else in the group. And the group included Menendez's then-girlfriend, Nadine Arslanian, who he later married, Menendez, and 3 other Egyptian men. And there were 2 surveillance teams at the restaurant, one inside and one outside. And they took a number of photographs as well as a video, which jurors saw in federal court in New York this week.
And the FBI agent testified that she heard Nadine Menendez ask, "What else can the love of my life do for you?" Was that the only incriminating statement she heard?
Yes. The investigative specialist, Terry Williams Thompson, who testified, said that that was what she heard, and they did not record the conversation when they videotaped this dinner. So that quote certainly suggests that Menendez had agreed to do something for these Egyptian men, and all this was happening at the same time that a co-defendant, Will Hanna, had recently secured an exclusive deal to inspect U.S. meat that was bound for Egypt and was certified as complying with halal standards. And Senator Menendez, we heard in testimony, called the top U.S. Department of Agriculture official who had complained to the Egyptian government that this sudden change in policy on halal meat inspections was hurting U.S. businesses because there were several other businesses that had previously had this job, and all of a sudden it was down to one business, and that was the one by Will Hanna, and he had no background at all in halal meat inspections. So that USDA official, Ted McKinney, testified last week and this week that he got a call out of the blue from Menendez right around the same time as this dinner, in which Menendez told him to stop interfering with my constituent. And he said that Menendez's tone was curt, and that when McKinney tried to explain what he was doing to Menendez, that the senator interrupted him.
And David, just to be clear, is the bribery charge related to this incident?
There are a couple of charges that it could relate to. One is there's a bribery charge that has to do with Will Hanna seeking Menendez to protect his monopoly. And Menendez is also accused of acting as an unregistered agent of Egypt.
Menendez's defense attorney portrayed this as just an innocent meeting, that the senator goes there all the time. He probably eats at that same restaurant at that same table 250 nights a year. And wow, that's a lot of steak.
The defense said that this was a routine matter for a U.S. senator. and that he was acting on behalf of a constituent, that he did not pressure McKinney, he didn't ask him to do anything corrupt.
This dinner was 4 years before the indictment. Was the FBI investigating Menendez for that long?
Well, we know from prior court filings that the FBI had raided Will Hanna's business in Edgewater, New Jersey, and there was an active investigation of Hanna, and they were looking into whether he was acting as an agent of Egypt. And the FBI employee who testified said that she did not know the subject of the investigation, but it was not Menendez. So that suggests that the FBI was working actively on another angle, and maybe they stumbled on Menendez.
Was the testimony sort of light at certain points? Because I read that the FBI agent was asked whether she ate while she was there, and she said, "I sure did, and it was good too." And then the judge said, "I hope the FBI paid for your meal."
That was definitely a fun moment in the testimony. She was talking about how she, had to dress the part and blend in, and that she was happy to do so at Morton's, which had a great menu.
I mean, this is the kind of testimony that jurors wake up for after, weeks and weeks of documents and bank records and the like.
It was definitely a captivating witness. And there was a lot about how she plied her craft as a surveillance person. I mean, she apparently goes from job to job to job, blending in, and it was fascinating to hear all this sort of spycraft in action.
Part of Menendez's strategy is to blame his wife, Nadine. She's going to be tried separately on the charges, so he won't be pointing at her while she's in the courtroom. Does the testimony of the prosecution's star witness implicate both Bob and Nadine Menendez?
Jose Uribe is a New Jersey businessman who pleaded guilty and is now cooperating with prosecutors. He testified that Bob Menendez, Nadine Menendez, and Will Hanna were all engaged in a bribery plot together, and he can offer an inside account of how this plot, at least as far as he was concerned, advanced. And his role in this case is that a associate of his was under state indictment, and we've reported that Bob Menendez met with the then Attorney General Gurbir Grewal and spoke to him about this case. The prosecutors say essentially that Uribe bribed Menendez to try to persuade the New Jersey Attorney General to influence the outcome of that indictment. It was an insurance fraud case, and that he also wanted Menendez's help in a second related criminal investigation that did not lead to any charges.
What have you seen from Menendez's defense so far?
What his lawyers have been carefully trying to do is parse out the nearly $500,000 in cash and the 13 gold bars that prosecutors say that he received as a result of bribes, and offer innocent explanations for why he received them, and also, through cross-examination, tried to show that a series of text messages and emails in which Nadine Menendez, then his girlfriend Nadine Arzlinian, arranged a series of meetings with Egyptian officials and Will Hanna that Senator Menendez said were not corrupt, and that he had nothing to do in any event with any of the financial problems that his then girlfriend, now wife, was experiencing at the time.
They're going to try to attempt to show that there was no corrupt intent, which is an element of bribery?
That's correct. And that he did not know that his wife was having a lot of financial problems when they got married. It was a second marriage for both of them. And he's also trying to show that his wife was in possession of a number of gold bars that he had nothing to do with, that the gold bars were given to his wife and not to him. And he didn't understand that Nadine's friends were trying to help her out of her financial problems. I mean, that's the defense story.
Has there been any indication that he would take the stand?
That's not clear. That's generally a decision that defense lawyers make at the end of a trial. after they've assessed how the evidence has come in. I would say that Menendez's political support in New Jersey and in the U.S. Senate has collapsed as a result of this case. Just this week, he filed to run in November for re-election as an independent Democrat because he's lost the support of the party. So I have to assume that any decision on testifying will also involve a political calculation on how the trial is being received publicly. He, of course, wants to be exonerated as a result of this trial and reelected. And there's the challenge he has of answering this very serious indictment and a large amount of evidence against him. He's got to balance that against the story that he tells to the public, which has only heard about the indictment, and a lot of the evidence cast him in a very unflattering light.
That is a really good point, because anyone who watches the news saw the photos of his jacket stuffed with cash and the gold bars and the Mercedes. So perhaps he has a little more to take into consideration than the average defendant in deciding whether to testify or not. This is the second time that Menendez has been tried on corruption charges. Tell us about the first trial.
Senator Menendez's first trial in 2017 was in Newark, New Jersey, in federal court, and he was accused of taking trips and other favors in exchange for helping a Florida eye doctor, Solomon Melgen. And there were some similarities in that Menendez was contacting government officials on Melgen's behalf, but the scale of the gifts in this case is just much larger. And the gold bars and the cash are just much more tangible bribes, as alleged by the prosecutors, than they were in the first case, in which the jury deadlocked and the judge ultimately declared a mistrial. In this case, for instance, the prosecutors passed around the gold bars so that jurors could actually hold them. And they've seen photographs of the cash that was seized by FBI agents when they raided the house that Bob and Nadine Menendez share in suburban New Jersey.
A gold bar is about as tangible as you can get. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.